to the ROC by company itself, I don't think they should go and apply, because it will be opening of Pandora's box for the company. Application of securities premium account. Any premium premium amount which is charged by company on issuance of shares. Now shares can be any kind or securities can be of any type. It may be share, debenture, it can be preference share, it can be even DVR shares. All those monies in excess of nominal value of shares has to be compulsorily transferred to securities premium account. And the provisions are similar which were there in 1956 Act. This Act also has the similar provision that securities premium account can be used only for issuance of either fresh capital or writing off liabilities with respect to redemption of any of the securities at premium. So let us see what are the provisions and in what circumstances share premium account can be used. Share premium account can be used only for the following purposes. That is, issue of bonus shares, writing off preliminary expenses or commission paid, discount allowed on issue of shares or debentures, providing premium on redemption or redeemable preference shares of a company, and for providing for buyback of shares. So these are the only 4 circumstances wherein securities premium account can be touched. If company touches the securities premium account for the purpose other than these 4, then it amounts to capital reduction, and company has to go to company law tribunal. Currently it's a high court, and usage of securities premium account for reasons specified using other than any of these 4 provisions, any of these 4 instances, capital reduction provisions will be applicable. Earlier section 100 to section 107 would be applicable. Company has to approach company law tribunal for this.
Here I have a question. For buyback of shares for
Other securities, it can be debentures, it can be preference shares also.
It's the own debentures and also.
Yeah, own debentures and securities.
I think in the ideal law it was not.
Yeah, it was permitted, but there was an amendment to this in earlier act. Once buyback provision started, I think it has started in the year 2002. Companies were allowed to do buyback of its securities. So post to that, it was allowed, and there was an amendment to this. Issue of sweat equity. Just to give you a brief idea of what sweat equity is. Suppose I am an inventor of a machine, but I don't have money to market that particular instrument. So I find out an investor, and that investor is ready to put money into my company so that I can market the device which I have identified and which I have patented. Now here I am supposed to liquidate my holding in the company. I am ready to do that, provided I get shares at a discount, because I am approaching investor because he is having money and I am having talent. So therein, what is the best method of issuing shares is, the investor will put in money, he will get shares at say rupees 10. I will not put anything, but I will get shares at say rupee 1 or rupees 10, whatever it is. But my consideration will be either nil or will be at discounted. So securities issued in such kind of circumstances are called as sweat equity. This is the only instance wherein company can issue shares at a discounted price. Otherwise, Companies Act 2013 prohibits issuance of securities at a discounted price. There are few conditions to be followed for this particular issuance. Those are: members' approval by special resolution is required. If a company wants to issue sweat equity shares, members' resolution by way of special resolution. 1 year after commencement of business has to happen. So issue can happen only after 1 year of commencement. Listed company has to follow listing agreement and applicable SEBI regulations. Explanatory statement. Company has to issue explanatory statement while issuing a special resolution notice. Company in its explanatory statement to that notice, company following things has to be there. That is, date of board meeting on which the issue is approved, reasons and justification, class of shares for which sweat equity is issued, total number of shares to be issued, names of the allottees, the price and consideration. If it is cash, then what is the cash? If it is non-cash, then what is the non-cash? What value it is? So there has to have a valuation report as well. And diluted EPS post issue of shares. Allotment of sweat equity shall be made within a period of 12 months from the date of passing of special resolution. Sweat equity shares, the number of sweat equity shares shall not exceed 15% of existing paid up capital or issue value more than 5 crore rupees, whichever is more. Quantum of sweat equity in any case cannot exceed 25% of the paid up equity capital of the company. All sweat equity shares shall be under lock-in for 3 years, and price will be determined based on valuation done by registered valuer. Amount of now issue of shares at a discount, that is sweat equity shares, shall be counted for managerial remuneration under section 197 and 98, and equity share, sweat equity share shall be counted as a managerial remuneration. Board report has to mention the number of equity shares, sweat equity shares issued, and the register has to be maintained in SH4, form SH4. About preference shares. Now, company may issue preference shares. Preference share comes with the bundle of rights, preferential rights, rights pertaining to dividend, rights pertaining to redemption of shares. Company can definitely do it, provided certain conditions are followed. Those are, company cannot issue irredeemable preference shares. Redemption of preference shares has to happen within 20 years, except in case of infrastructure companies. Infrastructure companies may issue preference shares with a period of 30 years. So that has to be redeemed within 30 years. Preference shares issue has to be authorized by articles of association, and in your capital clause of memorandum of association, your authorized capital has to have some arrangement for preference shares also. Special resolution is required to be passed for issuance of preference shares. Only fully paid up preference shares can be redeemed. So if there is redemption, first make the preference shares fully paid, then only it can be redeemed. The redemption can be out of profits of the company or proceeds of fresh issue of shares. So once preference shares are redeemed, that much space has to be occupied by way of issuance of further issue of capital or creation of capital redemption reserve. So that capital space has to be filled up through any of these mechanisms. And CRR also, that is mentioned in the next point, that CRR has to be created. Yes, that is possible. Fresh issue of preference shares can be possible. So either it is equity capital or preference capital, or you convert profit into CRR of that much amount. So that is possible. Transfer and transmission of instrument. Earlier we used to have a transfer deed, but now those transfer deeds are gone. There is a prescribed form, that is form SH4. This form has to be stamped, sealed and executed, and is required to be delivered to the company within 60 days of execution. So any form delivered to the company beyond 60 days of execution, company may reject accepting that, company has to reject that particular form, and within 2 months of submission of transfer date, company has to transfer shares in the name of, within 1 month of receipt of transfer date or form SH4, company must process the transfer of shares. Alteration of share capital. Now, company may alter its share capital in following ways: increasing authorized capital, consolidation of share capital, subdivision of share capital, and cancelling unissued shares of a company. Notice of alteration in share capital or redemption of preference share has to be given to ROC within 30 days. by passing a resolution, and that notice has to be given to ROC in form SH7, earlier form 5. Rights issue. Company, if in case wants further capital, it may either go for rights issue or preferential allotment. Rights issue is an issue wherein all the shareholders, existing shareholders of a company are given shares in equal proportion of their holding in the paid up capital of a company. That is called as rights issue. The offer shall be open for minimum period of 15 days and maximum period of 30 days. Recently there is a circular amending provisions for private limited companies, and now private limited companies did not have their offer, rights issue offer open for 15 days or 30 days. So if all the private limited company shareholder agrees to have offer open for only 2 days, that is possible, but that particular notification, that particular amendment is yet to be gazetted. So as on today, doesn't matter whether it is private company or public company, rights issue offer must be open for 15 days and maximum of 30 days. The article of association must contain provisions for renunciation of shares. So if a shares are offered to, there are two shareholders and shares are offered to both the shareholders in equal proportion. One shareholder doesn't have money, he have right to renunciate his right in favor of other shareholders, provided there is a provision in the articles for renunciation of rights. If article is silent, the renunciation right doesn't come automatically. There has to have a provision in articles of association. The board has authority to dispose shares not taken under offer in a manner not disadvantageous to other shareholders and the company. So board may have authority to dispose of that shares which are not taken. Further issue of capital, another mode is ESOP, employee stock option. Company can issue shares to employees. That issue of shares will be at a discounted price, but that discounted price should be a market price. So only case in which company can issue shares at a discount is sweat equity. Here shares are issued to employees of a company, discount to the market price. Full nominal value will be taken by the company, but it will be issued to the employees at a discount to the market price. So it may happen that XYZ Limited listed company having 10 rupees share nominal value, but listed in the stock exchange at rupees 1000. So company may make an issue to employee at rupees 20. So in that 20, 10 rupee will be the nominal value of a company and remaining 10 will be share premium. But the employee will get 1000 rupee worth shares at rupee 20 only, and the difference amount for them would be the remuneration paid to the employees. Special resolution is must. Listed company must follow SEBI ESOP guidelines. Explanatory statement shall consist of following things, that is total number of stock options to be granted, procedure of determination and identification of employees, vesting period, maximum period of vesting, exercise price and formula for arriving that exercise price, lock-in period, if there is any lock-in period, a statement to effect that company shall comply with accounting standards, applicable accounting standards. So that confirmation has to be there in the notice, in explanatory statement. There shall be minimum period of 1 year between grant of options and vesting of options. There are 3 stages of ESOP. One is granting the option. Company declares that out of 100 employees, A, B, C employees are allowed to having granted options. They can exercise those options only after vesting. So first one is granting of option. Employees are identified. Employee comes to know that yes, he can get up to 1 lakh shares under ESOP scheme. He can exercise those shares only after 1 year. So so these ESOPs are issued to employees just to retain them within the organization. So one is vesting, one is granting, and once shares are granted at any point of time, employee can come back to secretarial department of a company and can ask for shares. So once he asks for shares, he is supposed to do all the formalities. give application money, submit the formal application, and once shares are allotted to whom, he is allotted to that employee, he is ready to sell that shares in the market. So these are the procedures for issuance of ESOP. The board report shall contain details of number of shares issued under ESOP scheme. Register of ESOP shall be maintained in a prescribed form, that is form SH4. Now whatever registers I have just explained in all my slides, these registers has to be maintained from cutoff date, and the cutoff date given under company law is the law has become applicable from 1st of April. Within 6 months, all the registers has to be maintained in that format. That doesn't mean the registers which is maintained before 1st of April 2014 has to be rewritten. Whatever registers are there earlier need not be rewritten. Any new entries has to be there in the new format. So law does not ask you to maintain old registers also in new form. So there is a possibility that company will have two sets of registers, one before 1st April 2014 and one after 2014. But in registers for say register of members, nowadays these records are electronically maintained. RTA does the job. So for them only few commands they need to give it. So for having a register of member in electronic form is easier. But for old register, like say director attendance register, earlier it was not required at all. So now we cannot ask company that you are incorporated in 1980, show me all the directors attendance registers since 1980 because it is applicable. The law will be applicable from the cutoff date, that is 1st of April 2014, and from that also 6 months period is given to corporates to obey with that order. So the time will start from 1st of October, I believe, 4 plus 6. 1st of October, the records has to be maintained in the new format from 1st of October 2014. Any registers before that, it can be in the old format. Preferential basis. A company doesn't want to go for rights issue because rights issue is a bit cumbersome process, but the company has identified few private equity players. So shares can be issued to them on a private placement basis or on preferential basis. But for that, company has to have a special resolution. This is earlier section 81A. Articles of association must authorize all existing securities must be fully paid, then only company can go for preferential allotment. Allotment shall be made within a period of 12 months from the date of board resolution. Price shall be determined based on valuation report of the registered valuer. If the company is listed company, then the price has to be according to SEBI given formula, that is last traded 6 months price or last traded 2 weeks price from the relevant date, and the price has to be higher of both of these amounts. Explanatory statement must have object of the issue and total number of securities to be issued, pricing and basis for the pricing, relevant date. Now relevant date in case of preferential allotment is 30 days before the EGM date is called as relevant date, and all the countings, all the calculation has to be for all the calculation purposes that relevant date is a 30 days before the EGM date. Details of allottees, percentage held to be held by them prior to allotment and post allotment. While making preferential allotment, company has to be extremely careful. Since I work with the stock exchange, I know how careful company had to be. There was a company based in somewhere in Indore. They were about to make a preferential allotment, and under listing agreement, every company before making allotment of securities, they had to take approval under clause 24A of listing agreement, that is called as in principle approval before issuance. But the company hasn't made proper disclosure in explanatory statement. Stock exchanges did not give approval, and company were asked not to go ahead with that preferential allotment, and they had to redo their extraordinary general meeting with the new proposal and with the correct disclosures. So with this disclosure, with the disclosures pertaining to preferential allotment, company has to be extremely careful, especially for the percentage part, because in percentage part, company will give before allotment, this preferential allottee is having how many number of shares, percentage form, and post allotment how much percentage form and how much number of shares he will hold. So company has to be very careful in that disclosures. Also, any promoter or KMP, if have any intention to participate, that also will be disclosed, and in those circumstances KMP and promoter would become interested party. And now, even if you are interested shareholder, you cannot vote for the resolution which is put to vote. And time to complete the allotment. So this will be mentioned in explanatory statement. Other important points: company issuing shares to existing shareholders is not required to comply with these two returns. So these two returns did not be filed with Ministry of Corporate Affairs. Conversion of loan into equity capital may be done provided terms and conditions for accepting that loan is approved through special resolution. Issue of bonus shares. Yes, bonus issue is definitely permitted. Earlier Act was totally silent on bonus issue. There was not a single mentioning about bonus issue. The only reference was given in the model articles of association. But here the bonus issue provisions are there. Company may issue bonus shares out of its free reserves, securities premium account, and capital redemption reserve. For bonus issue, these are the conditions. Articles of association must authorize issuance of bonus. Approval of members is required. All shares of the company shall be fully paid before issuance of bonus shares. There should not be any default in payment of interest, dividend with respect to fixed deposit, with respect to statutory dues, with respect to employees. And once bonus issue is recommended, company cannot back out. So once declared, is declared. Reduction of share capital. Next faculty is he is covering buyback. So reduction of share capital I can definitely take. For reduction of share capital, yes, issued capital is not getting represented by assets of the company, then company may go for reduction of capital. Special resolution is a must. Approval from tribunal is required. There should not be any arrears to payment of deposit, acceptance of payment of deposit or interest. There should not be there should be proper notice issued to central government, tribunal, ROC, SEBI, creditors, even income tax department before going for reduction in capital. Wait for 3 months from the respective authorities to get their replies. If no reply is received from those authorities, then it is a deemed approval and presumptive approval, and company may NCLT may issue an order favoring company for reduction of capital. The order of tribunal has to be filed within 30 days with Ministry of Corporate Affairs. This section will not apply to buyback of shares because buyback of share is not capital reduction, because there is a separate provision relating to buyback of shares. So buyback and reduction of capital are totally different. Buyback of shares, other faculty is touching upon the subject, so I will not dwell into it. Issue of debenture, another very interesting topic. We all know that share is a share in share capital of a company, whereas debenture is share in borrowed capital of a company. Company may borrow money from the market. Even having creditors is one of the way company is borrowing. But when company needs liquid cash and company is really doing well, company may trade on equity and company may issue debentures to debentures. Now the debenture issue can be private placement, it can be public issue. So any of these things company can do it. But if company wants to raise borrowed funds from the market, this is the one way of doing it. That is issue of debenture. Now this debenture may be laced with option to convert, partly conversion, or no conversion at all. So there are various types of instruments. Those are either called we know in Sahara case OFCD debentures were issued. So you may give option to debenture holder to get converted or not. There are various types of debenture. However, just to make you know that a listed company cannot issue debenture. Listed company cannot issue debenture with a right to convert if the period is beyond 18 months. So in case of a listed company, in case of a listed company, convertible instrument, convertible debenture can be issued only if it is getting converted in 18 months. If it is beyond that, the listed company is not permitted to issue that convertible debenture. No debenture with voting rights. Debenture holder will not have any voting right. They will have voting right only with respect to debentures and their rights as a debenture holder. The company issuing secured debenture has to comply with following: Rule 18. Tenure of those debenture cannot be more than 10 years. In case of infrastructure bonds, it cannot be more than 30 years. Security to cover debenture amount and interest thereon. If the debentures are secured, appointment of debenture trustee is must. Creation of charge on that debenture is a must. Executive debenture trustee and appointed trustee within 60 days of issue of debentures. Security which is provided for debenture holder may be movable or immovable. Movable securities, if it is there, then it is called as hypothecation, and in case of immovable security, that is called as mortgage. So any of these kind of securities can be given. Debenture redemption reserve is must. Even if a private limited company issues debenture, 25% of profit must be transferred to debenture redemption reserve. So even for private company, creation of DIR is must, and public anyway it is must. Any company which proposes to issue debentures for more than 500 persons compulsorily has to appoint a debenture trustee. The company shall pay interest and redeem debentures as per terms agreed. If there is any change in the terms and conditions, it cannot happen unless and until meeting of debenture holders is convened and special resolution in that meeting is passed. Other provisions: issue of shares at a discount is in toto prohibited. Only exception is sweat equity shares. Of course, sweat equity are always at discount. Company cannot give finances to purchase its own shares. The only exception is listed company is forming trust, a welfare trust for its employees, and issuing shares to that welfare trust. So typically in this arrangement, what happens? Company doesn't issue fresh shares for ESOP purposes. Company forms a welfare trust for employees, that is called as ESOP trust. Company lends money to that ESOP trust. That ESOP trust buys shares from the market, and whenever there is ESOP allotment to be made to the employees, then in that case company doesn't make an allotment of equity shares, but the welfare trust transfers shares in the name of employees. So that way, if that is the working of ESOP trust, that doesn't amount to purchasing own securities. Otherwise, company cannot provide any finance to purchase its own securities. Amount equivalent to nominal value of bought back shares must be transferred to capital redemption reserve. Capital redemption reserve can be used only for the purpose of issuance of fully paid bonus shares and nomination of shares. Yes, there is a nomination facility given for nomination of shares. It was there earlier also. These are various forms with respect to shares and debentures. Format of the share certificate is given. Register of renewed and duplicate share certificate is required to be maintained if company has issued it. If it is not issued, of course, that will be nil. Register of sweat equity, securities transfer form, notice for transfer of partly paid securities, register of ESOP, alteration in share capital, letter of offer, declaration of solvency, register of shares and securities bought back. Then nomination form also is there, SH 13. Okay. Any doubt in the second part, issuance of debentures and shares? I'll go to next topic, that is dividend. Uh, 56 Act, there was no definition of dividend. 56 Act explained only interim dividend. Sorry. 56 Act explained only dividend but not interim dividend. But here, 2013 Act, the definition of dividend is there in section 2, subsection 35 defines dividend includes interim dividend. ICAI has also defined dividend. It defined dividend as a distribution to shareholders out of profits or reserves available for this purpose. Dividend can be distributed only out of free reserve. And I have not seen any definition of free reserve, but to my understanding, free reserve is a reserve which is not earmarked for any purpose. So any reserve which is earmarked for a particular purpose is not a free reserve. And any reserve other than this reserve is a free reserve. And all those reserves are available for distribution of dividend. Section 51 speaks that a company may declare a dividend provided it is authorized by Articles of Association. Company can declare dividend only in proportion to paid up share capital held by individual shareholders. There should not be any default by the company with respect to provisions related to deposits. If there is a default, company cannot declare dividend. Few more concepts: profit versus divisible profit. This difference has been discussed in Buenos Aires. It's a foreign case law. Now, a company could be doing a profit, but company is not having any divisible profit. So there could be a difference. Profit available for distribution and profit available for dividend is also are two concepts. Company may have 1 lakh rupee as a profit, but however, directors feels that 1 lakh rupee need not be distributed as a dividend. 70,000 rupees we must retain for plowing back profit for future, in case of future uncertain events, and only 30,000 rupees are available for dividend. So that is also, company may also given a freedom to decide what is profit for distribution and what is profit for dividend. Divisible profit will be after giving to preference dividend, because preference dividend is the liability anyway. That's the liability.
This will be taken equal for clarification.
No, I didn't get it. Huh. Yes. Yes. See, profit available for dividend will be in that circumstances. Now, this is not legally defined. This is just for an understanding purpose. That suppose a company is having profit of 1 lakh rupees and dividend to be paid to preference shareholder is 2 lakh rupees. Then only 1 lakh rupee will be paid to the preference shareholders. Their remaining profit will be remaining negative dividend has to be carried forward in the next year if it is a cumulative preference. It is possible in case of cumulative dividend, cumulative preference shares. The unpaid dividend can be carried forward to the next year. So if next year company is having 3 lakh rupees as a profit, last year's due of 1 lakh will be paid and current year's 2 lakh rupees will be paid. Again, equity shareholder will not have anything. But if preference shares are non-cumulative, in that case, if I am able to pay 1 lakh, I will pay 1 lakh. The rest is not my liability even for my next year. So before issuance of preference shares, company has to identify whether it is cumulative, non-cumulative, participative, non-participative. There are various ways of issuing preference shares as well. If it is a cumulative, then part payment of preference dividend this year may result into next year additional payment to preference shareholders. Dividend can be declared and paid by the company for any financial year, of course, out of profits of the company after providing depreciation. So first, depreciation has to be provided. And if central government or state government gives any guarantee, from that guarantee amount also dividend can be paid. Few provisions to that section 123. Provision number 1, company may decide that if they want to transfer any amount, any percentage on a regular basis to a reserve, so that will be taken care. Dividend must be paid out of accumulated profits in case of inadequacy. Suppose a company doesn't have profit enough to pay out of current year's profit, then company may pull out money from its earlier year's earned profit, and dividend can be paid out of that earlier years as well. If it is a loss, still company can pay. But if I am extracting from earlier year's profit, this year's depreciation has to be provided for. Then only once I pay for once I provide for depreciation, then only I can touch reserves for in case of inadequate profit.
Can dividend be paid without providing for depreciation, without provision for income tax?
No.
Can dividend be paid?
No. It has to be paid for taxation and depreciation. In fact, tax will come above the line, right? Yeah. Depreciation also has to be provided for. Then only I can go for payment of dividend. Yeah, tax expense. Yeah.
Total profit is here. Sorry, clear profit is here. But then accumulated losses. Then it will be paid.
No. Then in that case, you will adjust your accumulated losses against the profit. No dividend paid other than free resource. If the resource is earmarked for a purpose, dividend that resource cannot be touched. So it is paid only out of free resource of a company. Interim dividend. Yes, interim dividend is any dividend which is not a final dividend. A dividend which is not declared at annual general meeting of a company is called as interim dividend. So generally companies like IT companies like TCS, Infosys keep on declaring their dividend on quarter-to-quarter basis, and they finalize their whole dividend at annual general meeting and call it as a final dividend. So Infosys can do it. So even if other companies who quarter-on-quarter basis are earning profits, they can declare a dividend. Those dividends will be called as interim dividend. Rest all dividends are and dividend declared at AGM is final dividend. Interim dividend can be declared out of surplus in profit and loss account. Interesting fact to be noted: if company is incurring loss, interim dividend should be dividend less than average dividend paid in the last 3 years. So it cannot happen that last 3 years I'm having losses and I declare a huge interim dividend, and at the end of the year I found out I again have losses. So that should not be the case. So my dividend in case of loss in a particular quarter cannot be more than last 3 years average of the dividend. Deposit of declared dividend, most important provisions. The amount of dividend once declared has to be compulsorily deposited in a scheduled bank within a period of 5 days from the date of declaration of dividend, whether it is interim dividend or final dividend. The dividend shall be paid to shareholders or his auditor or his banker. Dividend declared but not been paid or claimed within 30 days from the date of declaration has to be transferred to unpaid dividend account within 7 days of such expiry. So once I declare dividend, within 37 days my account payment of dividend has to be converted into unpaid dividend account. Within 90 days of date of transfer to unpaid dividend account, the company must prepare a statement and must place it on website of the company that these are the shareholders to which dividend is not yet paid because of various reasons. So that if the company is having website, now company law doesn't make companies to have website compulsory. But if in case company is having website, then it has to be flashed on website of a company. Other private as well as public, but having website is not compulsory. If company is having website, then it must be flashed on company's website. If not having website, it's not compulsory. See, always wherever provision is there, must be published on a website, if any. I forgot to mention if any here. But if the company is having a website, then it has to be flashed on a website. However, ideally, company must. Sorry? No, same dividend account can be renamed as unpaid dividend account. Yeah, what will happen? I first open a dividend account. I issue letter to the banker saying that please rename this dividend account as an unpaid dividend account. So that is possible. Otherwise, I can't have two accounts. dividend account and unpaid dividend. So the same account I will get converted into unpaid dividend account. I think banks do that way also, right? If default is made in transferring full or part money to unpaid dividend account, penalty of 12% interest. The said interest shall accrue to benefit of members in proportion to amount remaining unpaid to them. So whatever 12% gets accumulated in that account, it will be distributed to the shareholders in proportion of their unpaid dividend account. Any claimant to the money transferred to unpaid dividend account may apply. Of course, unpaid dividend account, company can come, shareholder can come to the company, prove his rights as a shareholder, and company can pay dividend to him. Amount which remains unpaid for a period of 7 years in unpaid dividend account has to be compulsorily transferred to Investor Education and Protection Fund. If company doesn't do it, they are liable not only for penalty but for imprisonment as well. Now suppose on allotment of shares, few of the shares cannot be delivered to the shareholders, and shareholders also not coming forward to take the shares. So company has to compulsorily open a demat account in which unclaimed shareholders' share will lie. That's suspense account will lie. Now dividend pertaining to those unpaid shares will also be transferred to unpaid dividend account. A statement also has to be filed containing prescribed details. The details are prescribed. Such shares and dividend in future can be claimed from the company by proving your rights as a shareholder. Penal provisions on company, yes, non-compliance with any of the requirements of this section, there is a fine up to rupees 5 lakh and maximum penalty up to rupees 25 lakhs. On every officer of the company who is in default, non-compliance, there is a penalty up to rupees 1 lakh and maximum penalty up to rupees 5 lakhs. Any unpaid dividend account within 7 years has to be transferred to Investor Education Protection Fund. Central government has to establish this fund. The fund will be credited with an amount as specified in Section 2. Section 2 has specified various amounts to be transferred to this fund. Those amount involves payment of unpaid dividend on shares which is unclaimed by shareholders, payment of non-traced out debenture holders dividend, not traced out preference shareholders dividend, their redemption money. So all this money will be deposited into Investor Education and Protection Fund. The fund will be utilized as specified in Section 3. This involves education to investors. This involves spending by that money by central government, not only for educating investors, having various programs for investors. So it is basically for investor awareness that money can be used. Central government shall constitute authority for administration of the fund. Accounts of the fund shall be audited by Comptroller and Auditor General. Audit report will be placed before Parliamentary Committee of Central Government. Corporate action with respect to shares which are kept in abeyance. Now it could happen that the shares are held in physical form and share transfer deed has been submitted with the company but it is not yet processed and suddenly company declares a dividend. In those cases, though the new shareholder's name is not appearing in the register of member and the original shareholder is not owner of the shares, in that case the shares will be held under abeyance, and for those rights, the rights will not be transferred either to old shareholder or new shareholder. Once the transfer has happened, then only those rights will be transferred, then only those rights will be assigned to the new shareholders. That is called as shares held in abeyance. So this can happen even in case of bonus, even in case of rights issue, even in case of dividend, even in case of capital reduction. So in those circumstances, the shareholder's right also will be kept in abeyance, and once share transmission or share transfer have happened effected by the company, then the corporate rights will be given to the new shareholder of the company. Punishment for failure to declare a dividend. Dividend declared but not paid or warrant not posted within 30 days. Every director of the company shall be penalized up to rupees 1,000 per day and may be liable for 2 years of imprisonment, and defaulting company is liable for 18% per annum simple interest during the defaulting period. That's it. Any question on any of these three topics? Thank you, investors. Yeah. Sorry, issue minors. Technically speaking, as per Section 11 of Indian Contract Act, shares cannot be issued to minors because if there is an obligation of minor, whenever we enter into contract with minor can only be benefited out of that contract. There cannot be any obligation on the minor. So if a company issues shares to minor, say 10 rupees share, nominal value is rupees 10, paid up is only rupees 2. You are binding that minor for 8 rupees. So you cannot have an onerous contract with the minor. If minor is getting only benefit out of that contract, then that contract will be held as a valid contract. But from company law perspective as well as contract act perspective, minor cannot hold any property. So minor's nominee or minor's court receiver name will appear in the register of members. So minor cannot be issued shares in that case. The minor cannot be shareholder. Always his nominee's name or court receiver's name will be there in the share. If he is only legal heir in that circumstance, his name will appear there only as a beneficiary owner. He can get only benefits out of it. There will not be any liability on it. No, the person who enters into contract, for him the contract will be void. That contract will be void. That will not. So once minor turns into 18 years, he can say that whatever contract, whatever you asked me to sign, I signed it, but I am refuting the contract. So there will always be a danger after once he turns a major to say to it that no, that's not a valid contract. I was under influence, because minor always can claim that. See, it is up to company. Now it's a risk for the company. Company, nothing bars company from entering name of minor into share as a member. The only condition is that there cannot be any obligation on the minor. Now there were instances wherein demat account has been opened by depositories. Demat account has been opened by depository participants in the name of minor. But they were made aware of the fact that if there is any obligation on the minor, that obligation will be void. Minor can straight away refute it. So there were instances wherein shares are issued to minors. I am not saying those are illegal per se, but those are voidable at the instance of minor. Minor can say that no, I will get only benefits, I take only benefits, I don't want any obligations. Yeah, if the nominee assumes the responsibility in that case, if you remember earlier section 187C, wherein the person holds shares but not in his name. So in that case, nominee will hold shares not in his name. Nominee will file form 187C with the company saying that I am holding these securities in favor of so and so minor. Benefits has to be transferred to minor. Any obligation is there, I am responsible for that obligation. Yeah, no, it's not illegal per se. Definitely it can happen, but minor will get only benefits. Minor cannot ask for. Yes. He doesn't have legal obligation. Yes. So it's like this. There is a share certificate in the name of. There is a share certificate in the name of RP Sahasrabuddhe. Okay, I am the shareholder of that company. I am holding this share certificate. Suppose this share certificate is held by this sir. He is holder of the share certificate, but he is not a member. I am the member. So just by merely possessing, it's not like 10 rupee note. Anybody who is owner of that 10 rupee note, RBI is supposed to pay him 10 rupees. But this is not in case of share certificate. Now every shareholder need not be a member. That is, suppose physically, I bought a physical share certificate from Mr. X. He has signed transfer deed. He has given me his share certificate. I bought it from him, but now my name is not entered in the minute, not entered in the register of member. So I am a member. I am not a share. Sorry, I am the shareholder, but I am not a member. So till the time I don't go to company does the whole process. Company cancels his name, adds my name. I doesn't become member of a company. The shares are held in abeyance. My only duty is that once dividend is declared, I must go to company saying that these shares don't give dividend to that person. Because before declaration of dividend date, I became shareholder of a company. So that dividend, that corporate action will be held in abeyance. Only if name is registered as a member. Yes, right. But in demat mode, this really doesn't matter. Yeah, you declare a dividend. End of the day, whosoever shareholder, they get a dividend. Earlier in physical mode, whether the shares you are buying, ex dividend, cum dividend, so all that practical problems have been done away due to this depository mode.
What is the case of 1%?
Dividend. No, 1% company, only 1% is a member of a company. In 1% company, 2 members cannot become member of a company. It has to be 1% always. So, he will get a whole dividend in OPC. No, if he can transfer only to single person. He cannot transfer, and he cannot also transfer in parts. So if 1% company's number of members becomes 2, it automatically gets converted into a normal company, and he has to follow a process of converting OPC into private or public limited company. See, 1% company, it's a glorified form of proprietary concern. Yes, the benefits with OPC is you get limited liability. Second, you get corporate look. Whenever you go to say banker will look at the fact that yes, you are really professionally managed OPC. So you get some glamour if you have OPC. See, these OPCs came into existence in India only since 2013 Act. This is very old in even a country like Pakistan. Pakistan is having OPC since 1992. So we are very late to that. So it's a glorified form of only advantage is limited liability and corporate structure. These are the advantages. And you can have a brand name. So suppose I am an author. Instead of holding the royalty of my all authorship in my proprietary concern, because tomorrow anything can happen to me. So what I do, I found an OPC. I register my book with that OPC. So tomorrow anything happens to me, I will just sell the company and my royalty will also be transferred. But in case of person, in case of an individual, doing this is very difficult. And as a one man, it will not be possible for me to register my name RP Sahasrabuddhe. I cannot have a trademark on it. But suppose if I form an OPC with a name RPC OPC Limited, forming a trademark for me, getting a brand name for me is easier. Because generally trademark registry doesn't reject a trademark application if the name is company's name. Generally it doesn't happen. You get some say. And nobody can use it. Nobody else can use that name. Yeah, it is issued, but getting it difficult. Thank you. Register of charge you are talking? Yeah. If the forms are not filed within prescribed period, then the only 300 prescribed period. If it is not filed, the only way is to approach a CLB or company law tribunal, because they only can issue an order for ROC to get it registered. That is the only way out. Huh? Right? No, fine to anyway you will be paying up to 10 times. But yeah, no, you have to go to tribunal for that. There were instances that company were not able to do it. There were instances that company has to go to tribunal for getting it. Tribunal's approval only you can file it beyond 10 days. Huh? If you don't file it, then whenever penalty has to be paid afterwards. If you do not file the form, then there is in respective sections there are provisions for not filing, including imprisonment. So it's better to approach CLB. At least you have taken some steps. It shouldn't happen that the regulator comes to know that you are not filed it. Then you really won't have any defense left. You can say ignorance cannot be. You can say there was a delay, change of professionals, or give some health issues, something. Ignorance cannot be given. Anyway, there will be penalty. Anyway, there is a penalty. There will be some compounding you need to do. There will be. Yeah. Yes. See, whenever there is whenever with imprisonment there is either or fine, so it will be lightly considered and you will not be imprisoned. So there will be penalty and that's it. Compounding can happen. Yeah, you go by yourself and declare it rather than somebody else finding it out. No, that will be at the discretion of CLB bench, CLB or a tribunal bench. Yes. Afterwards, yeah, they will. It's a discretionary power, yeah. But generally, judiciary levies the list of the penalty because we are going ourselves. But if we don't go ourselves, then there will be highest of the penalty. It's better that we ourselves go. Yeah, imprisonment. I have not heard because of non-filing of return somebody is imprisoned. I have not heard it. Yes. Yeah, it's or yes. Yes, right. Yeah, because I did it yesterday, so I'm sorry for that. Yeah, sure. I think it will be uploaded by IC. Sorry? Yeah, you can download also. Or you can drop me an email at rahul@sprscs.com. I will reply to your email, sure. Yeah, it's Rahul at, I think it's given in the sheet. Rahul@sprscs.com.